So again, thank you all for joining us. Over the past 14 years, I have had the privilege of being deeply involved in leases, wearing different hats. Whether I'm negotiating a lease agreement for a landlord or for a tenant, in whichever industry. And it could be health, it could be life sciences, it could be research and education, it could be horticulture, retail, hotels, diplomatic services, you name it. Or even advising a party in distress, or also assisting with lease audits. And this experience has given me a broad perspective on the nuances of leases. And I'm happy to distill the topic that we're covering today into something valuable and practical for you. The topic being the overlooked risk of unregistered commercial leases. I am Lydia War. I'm the real estate partner at CDH Kenya. And that is Kieti Law LLP. Now, to give you a flavor of what I aim to cover, just 1 minute, Same, just checking that everything is okay before I proceed.
Yes, we're fine.
Perfect. Thank you. So to give you a flavor of what I aim to cover, obviously it's good to start with an introduction. And then we will look at the legal framework and ideally the principles that sit behind this proposition. And then after that, I will share the risk perspective. And of course, after that, we will finish. So why are we here? One of the most significant relationships in real estate relates to landlords and tenants. So therefore, it's not a surprise that these relationships are fertile grounds for disputes in real estate. And so why we're having this conversation is because I think the stakes are high. Because commercial leases, by their very nature, involve ongoing enforcement of rights and obligations throughout the term. The term can be short, the term can be long, because you're now speaking generally on leases. But the unique nature of commercial leases involves an ongoing enforcement of rights and obligations throughout whatever term parties have agreed to. And this can become complicated if there are differing interpretations of lease agreements and regulations and the expectations of the parties, right? Now, before we proceed, for those who roasted me, after the sectional titles webinar, saying that I spent too much time talking about the history of sectional properties, I want to assure you that again, I have detailed information on the doctrinal basis of the relationship between landlords and tenants from back in 1900 years. But I will spare you today. However, please allow me to just tell you a story, and then we will get to the point immediately after this. And perhaps you know the story. What you're seeing on the slide is an elephant, and what is supposed to be 6 blind men. Now, in this story, each blind man is obviously, as you can see, touching a different part of the elephant. So there's the one who's touching the tusk. This person thinks it's a spear.
Sorry, Lydia. Sorry to interrupt. Please start your slide from the top. It's showing slide number 10.
Oh.
And then put on presentation mode for us.
I don't know why I'm having a problem with technology. So I'm on slide number 3. Can you see it now?
It's still showing slide number 10.
Okay, apologies, everyone. Let me just stop sharing and start afresh. Sincere apologies for that. Or saying perhaps then you can share on my behalf, kindly. You can just go to slide number 3 because that's where we were. I'm really sorry about that.
It's okay. Give me a minute. Better?
Yes. Again, apologies. So I was trying to demonstrate the analogy in this story. So as I said, the story is about an elephant and what is supposed to be 6 blind men, as you can see. And one of the men, as you can see, is touching the tail, and he thinks that that is a rope, right? And you can see someone else touching the ear, and they think it's a fan. Someone is touching the leg, and they think it's a wall. Someone else is touching the tusk, and they think it's a spear. And you realize that they all conclude that the elephant is something completely different based on their perspective. None of them is grasping the full picture because they fail to consider all the aspects of this elephant. So you can move to the next slide. So likewise, stakeholders may focus on isolated aspects of a lease without addressing the bigger picture. Now, in the context of the story that I have just shared, each party's perspective, be it a tenant, an advocate, or a landlord, may be different, leading to fragmented understanding and decision-making. And that would mean that the importance of registration might be overlooked by these parties or even minimized because some parties perceive it as a minor administrative step, failing to recognize the long-term risks associated with making the decision not to register the leases. I really hope that made sense, even in light of the hiccup. But I was just trying to make the point with that analogy that sometimes when we don't look at things holistically, we may end up overlooking certain critical aspects or even minimizing certain aspects that should not be minimized to the detriment of the party or the party that you aim to represent if you're a legal advisor. I really do hope that made sense. And in practice, we talk about which hat you're wearing, essentially meaning who are you representing in the matter. It helps to inform how you need to show up for your client in that specific transaction. So you need to keep that in mind even as we continue with this conversation. What I'm trying to do is, going forward, I'm trying to show you all the parts of the elephant in relation to commercial leases. And then after, we will put all this together. And by this, I mean highlighting the legal provisions that apply in relation to the topic that we are covering. And then now moving on to the risk perspective. So saying you can move to the next slide. Okay. Now you can see that brings us to the Land Act 2012. And here we're again discussing the legal framework of leases. So in terms of the legal framework of leases, before I proceed, let me just say I am focusing on the Land Act 2012, the Land Registration Act 2012, and the Land Laws Amendment Act 2016. The 2016 Act introduced amendments to the 2012 Acts, so I won't dwell too much on it, but just to remind you that you always have to check the 2016 Act so that you are updated, because I know there's so many people who forget that we have 2016 amendments, and some could be fundamental. So you either update your 2012 Acts like we do, or you endeavor to just check whether there are any associated amendments under the 2016 Act. So we will start with the Land Act, and we're looking at Section 2, just to help us understand what a lease is from a legal perspective. And I took a screenshot to avoid imposing my own interpretation when paraphrasing. So I guess we can read it together. A lease means the grant with or without consideration by the proprietor of land of the right to exclusive possession of his or her land, and includes the right so granted and the instrument granting it. And it also includes a sublease, but does not include an agreement for lease. There's a contradiction with that last part, but that's a separate conversation, because on one hand, the definition of the lease says it does not include an agreement for lease, but we have a separate definition of what amounts to a disposition, which says that it may include the agreement, Okay, so I will explain why I have highlighted the right to the exclusive possession. Then further along, you see who is defined as a lessee, and a lessee is a tenant. So I'll be using these words interchangeably. Lessee means the tenant, lessor means the landlord. So the lessee means a person to whom a lease is granted. I've seen a comment on the chat asking whether the slides will be shared. They will be shared immediately after this, together with the recording. So the lessee means a person to whom a lease is granted, and includes a person who has accepted the transfer or assignment of a lease. I think that's self-explanatory. And then a lessor means a person by whom a lease is granted, and includes the person who has accepted the transfer, right? So let me explain what I meant by exclusive possession, why I highlighted what you're seeing on the screen. Exclusive possession is actually the hallmark of a lease, and that's why I have highlighted it. It is the right of a tenant, and again, I will use these words interchangeably, so whenever I'm referring to a tenant, I mean the lessee. This exclusive possession is the right of the tenant to exercise control over those leased premises to the exclusion of others. But of course, subject to the agreements or covenants in the lease agreement. And this right is only limited to the agreed lease term, right? So the landlord, in this case, the landlord retains the ownership of the premises, but cannot interfere with the tenant's quiet use and enjoyment of the premises during the term. And again, I will emphasize, of course, this is subject to the lease conditions. So I need to highlight that this is the main differentiator between a lease and a license, because ideally a license cannot grant you exclusive possession. Even just as the name suggests, a license, it should not grant you exclusive possession. But again, I will add that this is still connected to the intention of the parties, because there's case law in relation to what is perceived within the document, or what is written in the document, and how the document is marked. So, for example, a document can be marked a license, but upon interpretation, when they're now looking at the document, it appears that the intention of the parties was to confer exclusive possession. So I'm adding that rider just to highlight that there could be case law emanating from interpretation of some documents on a case-by-case basis, and there could be a differing perspective in that. But ideally, overall, a license is not supposed to grant exclusive use and possession. So, Saini, you could please help me move to the next slide. Now, the next provision we are looking at is Section 58 of the Land Act 2012, because this is how you determine which lease ought or which leases ought to be registered. And it's simply by interpretation of this section, especially Section 58.3, which we will get to. So again, we can just look at these sections together. Section 58 talks about short-term leases, and it defines what a short-term lease is. And then it proceeds to say that a short-term lease is not a registrable interest in land. So the bottom line under this provision is that a lease of up to 2 years does not need to be registered against the landlord's title. But if you're drafting or if you're a landlord and you're granting a lease, just remember that the provision is very clear. 58.1a is very clear that it is a lease made for a term of 2 years or less without an option for renewal. So the minute you include an option for renewal in that place, then it falls away. This exemption falls away because now you cease being a short-term lease by virtue of that interpretation. And then what I'm also saying is that under Section 58.3, by contrast, any lease that does not qualify as a short-term lease, therefore is not exempt and would require registration. So that's how you determine which lease would require registration and which lease would not require registration. And why we're saying it would require registration is because registration is what would make it legally valid and enforceable as an interest in land, right? I will explain that as we proceed. Saini, you could move to the next slide, please. Okay, so let's now look at the provisions of the Land Registration Act 2012, still covering the legal framework. Starting with Section 24 regarding the interest conferred by registration. Again, we can read it together. The registration of a person as the proprietor of land shall vest in that person the absolute ownership of that land together with all rights. I need you to mark that differentiator, the absolute ownership of the land. Then it proceeds under Section 24b to say that the registration of a person as the proprietor of a lease, see the differentiator, 24a talks about land, 24b talks about a lease. And it says it will vest in that person the leasehold interest described in the lease, together with all implied and expressed rights and privileges, but of course, subject to all implied and expressed agreements. So key differentiators I'm seeing here is 24a talks about registration of a person as a proprietor of land, and it says it vests in that person the absolute ownership of the land. Then 24b talks about the proprietor of a lease, and it says it vests in that person the leasehold interest described in the lease. That's a key differentiator. And here we are talking about what is the effect of registration. Now, let me just say, land registration systems are designed to ensure the clarity and enforceability of interests in land, right? So in my view, Section 24 of the Land Registration Act establishes the legal significance of registering an interest in land or a lease. This section actually is what establishes the significance of registration. Now, regarding leases, right? Registration, as I've said, vests the legal interest described in the lease to the registered tenant. Yeah. What that does is that it puts the tenant in what we call a leaseholder position. This is key to understand. Registration would then put the tenant in a leaseholder position. What that means is that this is a legal recognition that now elevates that lease from a contractual arrangement, because remember we have a lease agreement, right? So the aspect of registration now elevates that that arrangement from being that lease from being a contractual arrangement to a registered interest in land. And what does that mean? It means that registration then confers rights which are enforceable against third parties. Without registration, the lease is considered a contractual arrangement. And this is a contractual arrangement only between the tenant and the landlord. So it's good to understand that. And then the other thing that highlights what being in a leaseholder position means is that by virtue of that registration, then the tenant's interests against interest in the premises are protected against subsequent dealings with the property. And I will discuss that. I will elaborate what that means. So I'm differentiating what it means for the tenant to be in a contractual arrangement, meaning that they have negotiated the lease agreement and it's been signed and exchanged between the landlord and the tenant. So you're in a contractual arrangement already. And then as compared to the tenant being in a leaseholder position by virtue of registration of that lease. Now, I have also clarified on this slide that I am not referring to the disposition of a lease under Section 32, and I won't get into that. But you know, I don't know, for the nitpickers or those ones who want to absolute clarity on the information, I'm not referring to the disposition of a lease. I'm just referring to I'm not referring to the disposition of a lease under Section 32. My understanding of Section 32 in relation to the disposition of a lease would be what happens after the lease is in place. Now, the disposition of that lease. So many transactions can happen after a lease is in place. There could be an assignment, there could be a surrender, there could be an novation, there could be an extension, there could be a variation. So I think that is what falls under the realm of Section 32 of this Act. Saini, could please move to the next slide. So next, as you can see, is Section 36(2) of the Land Registration Act, which I should say is quite popular, right? This section provides that nothing shall be construed as preventing any unregistered instrument from operating as a contract. I am saying that this provision is popular because so many people take comfort in it. By virtue of the provision saying that nothing can prevent an unregistered instrument from operating as a contract. And I hope we are connecting the dots, you know, as we go along. I've established which leases ought to be registered by virtue of interpretation of Section 58(3). I have defined what constitutes a lease. I have discussed the effect of registration. And now we are looking at Section 36(2), which says that nothing shall be construed as preventing any unregistered instrument from operating as a contract, right? Now, why I'm saying people take a lot of comfort in this is because I am aware of many lease arrangements where parties stop at the exchange of contracts. So they negotiate heavily, they sign the contracts, and then they exchange and leave it at that, right? At that point, they're in a contractual arrangement. And this section validates that, you know, that would be the operating arrangement between the parties. There's nothing wrong with that, right? And I've also seen people electing not to proceed with stamping of these lease agreements, arguing that because there's a requirement for, you know, documents that need to be presented in court as part of evidence to be stamped with the appropriate duty. So I've seen people going as far as not stamping the documents and arguing that should there be a dispute in the future, then they can still go ahead and stamp, their documents then, and they can always pay whatever penalties have accrued in terms of stamp duty. So I've seen that, and I appreciate that people have different risk profiles, right? However, it's good to understand that what it means when you're in a contractual arrangement, instead of being in a leaseholder arrangement, is that, yes, the contract may govern the relationship between the parties, that is the landlord and the tenant, but without registration, it does not create an enforceable legal interest in the land. So while the parties might still be bound by this agreement that they have signed and exchanged, the lease won't be enforceable as a legal interest. Those are keywords that you need to understand. As a legal interest in land. For you to get that legal interest in land, there has to be registration. Registration has to be effected. Now, I have an old friend who used to say, so what? Whenever you're making a point, she would always say, so what? I will get to that shortly. Saying you can move to the next slide. Lastly, you can see here we're looking at section 43 of the Land Registration Act. I hope I clarified that section 36.2, the one we just looked at, was under the Land Registration Act. Now we are looking at section 43 of the Land Registration Act. Here again, the bottom line under section 43.2, as you can see, and I was very deliberate with that amendment that you can see, just demonstrating that you always have to check the 2016 amendments. So what essentially section 43.2 is communicating, in order for that contract that has been signed between the landlord and the tenant to create a lease, it would have to be registered, provided that it is not exempt from this requirement. So that is the summary of the legal framework that I wanted to highlight. Yes, the session is being recorded and the recording will be shared. So that's the summary of the legal framework that I wanted to highlight. So whenever you are applying your mind, regardless of the party that you're representing, always consider these provisions that I'm highlighting. Look at them in totality. Don't just touch one part of the elephant and then advise your client. Look at all the provisions that apply to this transaction holistically. Saini, could please move to the next slide? Great. Now, this is a bonus slide where I'm trying to link the nature of the tenancy and the types of the tenants in commercial leases to the unique exposures due to the absence of registration of their leases, right? And these are just examples of the types of tenants to show you their unique considerations and why for them, security of tenure is supreme. And this is not, everything. These are just examples. So I've highlighted office leases, retail leases, industrial leases, and this one is critical for me, mixed-use leases, because as you can see, I've given the example of horticulture, which may ideally fit within the definition of agricultural use, but there may be some production activities happening there. So there could be an extension of that use, therefore inviting the interpretation of that lease being a commercial lease. So as you can see on the slide, these considerations are fundamental because we're looking at the tenants who are concerned about prime location. There are tenants who are concerned about customer traffic. This is self-explanatory. When you're looking at these supermarkets, there are tenants who are very particular about location-specific infrastructure. And why I was highlighting industrial leases is because these tenants invest heavily in equipment and infrastructure. So of course, they would need to cushion themselves against any form of exposure. And when we're talking about any form of exposure, this includes the fact that you may not have security of tenure in the sense that your lease has not been secured. In the sense that you're not in a leaseholder position, right? So, as I said, that was a bonus slide, just trying to connect the caliber of these tenants, the kind of investment they pump into these premises, and the extent of protection that this caliber of tenant then demands, right? So you can move to the next slide. So this is basically the crux of what we are discussing today, the risk perspective. The risk perspective, which I am arguing that sometimes tends to be overlooked, right? And I'm talking about third-party situations. Try to connect the dots so that you stay with me. I have differentiated what it means for parties to be in a contractual arrangement, which, as I've said, there's no problem under Section 36(2) of the Land Registration Act. And I've also highlighted what is the effect of registration. What does registration do for the recipient of the lease? It elevates you from the contractual arrangement to a leaseholder position. And I have highlighted what being in a leaseholder position means now. And within that conversation, I said, being in a leaseholder position protects you against third-party situations that can interfere with your lease. Now, let's look at some of these third-party situations that can affect an unregistered, registrable lease. I'm trying to be very particular about that, yeah? So we are simply focusing on leases that ought to be registered, as we've seen under Section 58(3), and what third-party situations, how third-party situations can affect unregistered, registrable leases. So number one, as you can see on the slide, sale of the property. Now, the landlord who retains absolute ownership of the property can decide to sell the property. When they do so, the new owner will not be bound by the contractual arrangement that exists between the tenant and the landlord, right? Now, what that means is that a tenant can lose their right to occupy the leased premises despite their heavy investment, just because they are not cushioned against third parties. It may sound extreme to some, but the reality exists. The reality of you being in a contractual position so you're not able to enforce against third parties is potent. Should a landlord decide to sell and your interest is not registered against the land, then you may ideally or potentially lose your right to occupy the leased premises by virtue of that sale. Now, the second aspect I wanted to highlight is in relation to creation of charges. Of course, we had amendments in 2012, so we no longer have mortgages in Kenya. So in terms of creation of charges, if a landlord creates a legal charge of a property, the financier's rights may take precedence over an unregistered lease. That's very important. So what that means is that a tenant will have no legal standing when the lender is enforcing their rights. And I'm not saying that you can't enforce the contract between yourself, the tenant, and the landlord. What I'm saying is that you will not have a legal standing in relation to having cushioned yourself against third-party interference when this lender is enforcing their rights. And I've had separate conversations with people who ask me, or clients who ask me, what if the lender now wants to register their lease and they find that there's an existing, a lender wants to register their charge and they find that there's an existing registered lease against the property, because lenders don't want to be in that position where there's another interest that has been recorded prior to theirs, unless there are other arrangements like security sharing, interlenders, etc. So what such lenders normally do, some lenders normally do, is to request for a subordination of that lease. So whenever a lender finds that there's a lease that has been registered and they feel like it minimizes their security, they can always ask for a subordination. So then a deed of subordination is procured, and then the lender's interest would rank higher. But back to what the exposure is to the tenant who has not registered their lease, you are exposed in terms of you can't enforce your rights when the lender is enforcing their rights. Now, the third aspect is the landlord's insolvency, which I think is self-explanatory. Because when a landlord becomes insolvent and they're reviewing what interests are protected and can be recognized, an unregistered lease may not be recognized as a protected interest. Therefore, it will leave you exposed as a tenant. But of course, this depends on what the circumstances dictate in that situation. Now, the third issue is the landlord's death or demise. A tenant's long-term planning and investments can be jeopardized by succession issues. This is one aspect that I always remind my clients not to overlook. You must always consider the possibility of death when you're dealing with natural persons and how it can affect you or this transaction or your rights. I once wrote an article on this, dubbed Contracts of the Dead. And even in the making of that article, I could feel the pain of those who did not secure their interests as required. Again, back to the analogy. Don't stop at section 36.2, which tells you that nothing precludes that arrangement, that document that you're holding from acting as a contract. But the question is, are you in a leaseholder position? And if you're not, what does that mean? Now, the next aspect that I highlighted is change of user. Because of course, one of the things that we check, especially when we're acting for tenants, and this is why we will ask immediately for the copy of the title with the special conditions, because the special conditions indicate the permitted use, as recorded. So the permitted use of that property has to permit the expected use of the lease, right? So if for example, if the lease is supposed to be, if the tenant wants to use the premises for as office premises, then we would flag it as an issue if the permitted use in that area is residential, private dwelling, because there's no correlation and there's exposure there, different conversation. But what I'm saying is that lack of registration can leave a tenant exposed to the changes in how the property is used. And what this means is that it could conflict with the intended permitted use or even disrupt the tenant's operations. So what registration provides is a basis for a tenant to be consulted during a change of use application, or let me say zoning reclassifications. As a tenant, you could end up being forced out. For some, this may seem extreme, but you have to always consider the possibility of a tenant being forced out given the change of use. Because as I've said, the permitted use in the lease always has to align with the permitted use in the special conditions attached to the property. So if a change of use occurs, wouldn't you be in a position where you could be forced out given the change of user? Think about it. Or even a lease can be voided simply on the basis that the user designation is no longer compatible with the tenant's activities. Don't overlook that. Think critically about it. And the last one, which ties to everything we are saying, relates back to everything that I have discussed so far, is the loss of priority generally. So as I've said, registration secures your interest. But then I'm also talking about loss of priority during government-imposed activities, because sometimes there could be government-imposed activities or directives, sorry. And if a property is undergoing such and your interest is not registered against the title, the landlord's title, then your interests as a tenant may be overlooked during that process. Okay? So always remember, I'm highlighting a lot to do with third-party claims and how this can affect you as a tenant if you did not take the next step to register that lease. I think, Sane, you can go to the next slide. Sane, I hope you can hear me.
Yes, we're on the
conclusion. Okay, so just go back. I think I need to make another comment. So ideally, as you can see, this webinar is more likely to improve a tenant's IQ, because ideally what I have described are statutory protections afforded to a tenant. Non-registration can disrupt, and now let me call this a rant, but I'm trying to show you how to think or how to analyze the circumstances, right? Non-registration can disrupt a tenant's exclusive possession, since an unregistered lease cannot be enforced against third parties. Think about it. You remember when we started, we said the hallmark of a lease is exclusive possession. So fine, the document that you have negotiated and secured has granted you that exclusive possession, but you haven't taken a step to cushion yourself against third-party claims. In my view, that essentially undermines a tenant's exclusive possession, because if a third-party claim arises, then you cannot enforce that interest that you're holding as an interest in land. You can only enforce that contract that you have between you and the landlord. And as we are aware, courts have more and more decided that sometimes being granted damages in such cases is more ideal than allowing specific performance of these contracts. So doesn't that put you in a precarious position as a tenant? And then by extension, non-registration can create uncertainty over rights or intentions, or over certain rights or intentions, such as the lease renewal, because we're normally big on the lease renewal clause. If a tenant wants this as a fundamental offering in the lease, in my view, then not securing the tenant's rights could interfere with what you have already secured in your contract, because there's a contradiction there, right? If there's a sale, now looking at these examples we've given under third-party obligations, you had spent a lot of time negotiating the renewal, and the renewal normally says, for example, I'm giving you 5 years of 6 years, a term of 6 years, but I'm also giving you the option to renew this lease. So it's projecting to the tenant that on expiry of this lease term, should they want to extend their stay, then they would have that option. And it is fundamental that we incorporate that provision in the lease agreement if the tenant requires. Now, we have successfully negotiated that, and the contract has the lease renewal provision. Then you do not register the lease. Then there's a sale that is happening. It means then to me that there was No point at all, because by virtue of the fact that you have not secured your interest against third-party claims means that even that right that you had secured to renew in future, cannot be secured, can no longer be secured because there's an overriding third-party claim. Yeah. And then I would also argue that to some extent, non-registration of a lease, how do I put this? I would also argue that, yes, to some extent, non-registration of a lease contradicts the force majeure clause. And how do I mean? Because on one hand, you're trying to shield yourself from unforeseen risks, right? And then you fail to take a step which would ensure that your interests as a tenant are secured against unforeseeable third-party claims. I hope I'm making sense. So on one hand, a tenant has heavily negotiated a force majeure clause, trying to protect themselves against unforeseen risks. But then there's this list of unforeseeable third-party claims that I'm trying to highlight, which you can only cushion yourself against them if you take the further step of registering the lease. For me, it's a contradiction. It means that we're not looking at this thing holistically, right? So always keep that in mind. And for me, the bottom line is, or the keyword is, third-party claims. Have you cushioned yourself, right? Even if you are an informed tenant, have you weighed the risk, and are you comfortable with the risk that you're taking by not registering your lease and staying with the contract as a commercial arrangement? Okay, so saying you can move to the last slide. Perfect. So as you can see, the law of the landlords, or let me say the law of landlords and tenants, is shaped by both contracts, because we've talked about the contractual arrangement, and the landlords, because I've also highlighted the legal framework that applies. But at the end of the day, it's important to understand the risk landscape of unregistered leases. That is the crux of this webinar. It's always important to understand the risk landscape of holding an unregistered lease. I should also add that as a legal advisor, because I know we have professional colleagues here, so as a legal advisor representing a tenant, you always need to consider what failing to mention these things I'm highlighting under the risk perspective. You always need to consider what failing to mention these things to the tenant would mean from a professional negligence perspective. Because now we are understanding the totality of it. We've seen what the framework is under our laws. We've seen the exposure in terms of not securing yourself against third-party claims, not being in a leaseholder position. So you as a legal advisor, if you fail to highlight these circumstances to your client, have you considered what that means from a professional negligence perspective? Think about it. And then let me also say that registration of a lease, just to drive the point home, registration of a lease is a matter of transforming a lease again from a simple contract to a real property right. It matters. It matters, and you have to consider it when you're making the decision, when you're electing not to register your lease. Yeah? And we now understand what being in a leaseholder position means. So advising a tenant without considering the implications of non-registration, in my view, is like touching only one part of this elephant and missing the overall context. I hope the analogy drove the point home. Now, in conclusion, I have to say that my overall goal is to guide you on how to think critically about lease agreements and equip you with the tools to navigate, these complexities that we're looking at. So yeah, especially, I'm not trying to provide a one size fits all answer, but I'm just trying to highlight the nuances and how you're supposed to apply your mind, obviously, depending on the circumstances and depending on the client that you are representing, or depending on which party you are, if you're a landlord or a tenant. Okay, I think that's that. I think that concludes our webinar today. If you have specific issues that you would like to explore in relation to this topic, please feel free to reach out. We at CDH, we are always ready to assist with tailored advice and solutions. We are always reachable. And I think we try and think outside the box so that we offer the best outcome for our clients. So thank you again, and please keep an eye out for the next webinar. And I don't know if there are any questions that maybe we could try and answer one question before we conclude.
Yes, there are questions in the chat box.
Sorry, I didn't get you there, Nan.
There are questions in the chat box.
Okay, let me just see. So I'm seeing a question here. What is a reasonable period when all parties and stakeholders are expected to sign and register a commercial lease? So we don't have a prescribed period for signing a lease. But I believe there is a prescribed period for registration by virtue of, I'm trying to remember, there's a provision in one of the 2017 regulations that talks about when penalties start to accrue post dating of the document, and in relation to when you actually presented the document for registration. I need to check. I'm not sure if it's 3 months. I believe it should be 3 months. But just to answer your question, there's no prescribed time frame for signing of the lease agreement, because these documents are heavily negotiated. I've seen some lease agreements being negotiated for a whole year, and it depends on the industry. It depends on what the stakes are. It depends on the parties, and also it depends on the legal advisors sometimes. Yeah. So there's no time frame for signing, but there is a time frame for registration of the leases. I just have to double check, but I think it's 3 years in terms of when penalties start to accrue after the date when you are supposed to have presented the lease agreement for registration. Is there a benefit or a risk associated to the landlord for not registering a lease? Yeah, obviously, as I've said, this webinar ideally improves the IQ of the tenant because they have the most to lose by not registering the lease. So the landlord in our jurisdiction doesn't have much to lose, because what it means is that they're not tied to getting the consent of the tenant or things like that, or whatever obligations they have committed to in the lease, if that lease is not registered as an interest. And let me just be clear because of terminology and the nuances. So remember that slide where we were talking about the landlord being able to sell the property, and the third party who's buying not being bound by the existence of an unregistered lease. That can be perceived to be a benefit to the landlord because you're not fettered by the fact that there's this registered encumbrance against your property. But in certain jurisdictions, they would say that a landlord who is holding unregistered leases. Now let's think about a building, a commercial building in town that has 100 or 1,000 tenants, let me say that. And the landlord wants to borrow from a lender. And what they're telling the lender, they're trying to demonstrate the value of that building and the income it's generating to the lender by saying that we have 1,000 tenants in this building. In certain jurisdictions, how you demonstrate the value of this property would be by presenting registered leases, because that is how those lenders would take comfort in the fact that you ideally have 1,000 tenants there, and there's this stream of income that is expected for this number of years, right? So in securities documentation, there's normally a document called that assigns the rental income. And in certain jurisdictions, for them to see whether that is a solid security that they're taking, these lenders would want to see, or would want it to be demonstrated that the landlord has actually secured these tenancies. And in their perspective, securing these tenancies means having registered leases against the title. So it depends. But in our jurisdiction, the attitude normally is that non-registration of a lease agreement actually works to the detriment of the tenant, but in favor of a landlord. I think I can try and take one last question. What is your opinion on registering leases between related or sister companies? And can such companies choose not to register or stamp? Not so sure I fully understand that question, but this is how we normally negotiate for tenants. So the first draft that would come from the landlord in relation to the assignment clause, because that's where this question is emanating from, would normally say that you can't sublet, transfer, assign, part with this lease without. Actually, some would say you just can't sublet, you can't assign, you can't deal in such manner. But some would say you can't do that without the written consent of the landlord, right? And then when you receive it as a tenant's advocate, now you have to understand the objectives of your client. And for corporate clients, we know that there could be, especially corporate clients who fall within a group of companies, we know that there could be, okay, so for corporate clients who fall within a group of companies, that's a good example. But I've also seen situations where we are representing research institutions or even universities, right? And they would have collaborators. So the person negotiating, for purposes of just giving an example, would be, the tenant would be, say, the University of Nairobi, but they would have collaborators. And they're projecting that at some point, they may have to assign this lease arrangement to their collaborators. Similar, these corporate clients may project that when they're reorganizing their affairs in the company, they may want to assign this lease arrangement to their affiliates. So what you as a tenant, as the person who's representing the tenant should do is to ensure that if it is fundamental in the circumstances that you're handling, for there to be that allowance, yeah, then you have to ensure that you negotiate for an assignment clause that permits an assignment to an affiliate. You have to carefully demonstrate what amounts to an assignment. If there are percentages there, you have to review those percentages. Are they saying 2%? Are they saying 3%? What is the threshold? What would make sense? Yeah. You also have to consider how that clause is worded. And if the situation arises, would it inconvenience your client in any way? And if it will inconvenience your client in any way, then you have to tidy up that clause by adjusting it to allow your client to, carry out their affairs without being inconvenienced in any way. And you also have to have the legal understanding to be able to convince the landlord and their advocates that there's no malice, that you're not trying to commodify, I don't know how to put it, but you're not trying to to get them into a situation where you're just exiting without having regard to their requirements as well. Because landlords also have to vet the caliber of tenants that they're taking. Yeah. So you can't just assign to anybody, because a landlord always reserves the right to determine who they want to associate with as a tenant. So the long and short of what I'm saying is you have to understand who your client is and the circumstances. And if your client falls within the category of clients who may need to either assign to their collaborators, I've even seen embassies saying that, circumstances may force us to relocate person X from here, but we still want to stay with the lease. That means that we have to assign to another person. So please do not see it as an inconvenience, and please do not inconvenience us during this period. It's just supposed to be a seamless transition, because the vetting and the due diligence of the ultimate occupant of the premises has been done, and the landlord should be comfortable. So which hat are you wearing? Who are you representing? Look at that clause keenly and try to deliver the best outcome to your client. Okay, I think that's about what we are able to cover. Again, let me thank you for attending this session, and please look out for the next webinars. I hope you can join us. Thank you so much for your time.